Hello. This time we will discuss Article 4, criminal liability. Article 4 of the Revised Penal Code provides that criminal liability shall be incurred by any person committing a felony. Felony is a term used in the Revised Penal Code, while other special penal law uses felony, crime, or offense. Now, first is criminal liability under Article 4 attaches when by any person committing a felony, although the wrongful act done be different from that which he intended. Second is by any person performing an act which would be an offense against person or property, were it not for inherent impossibility of its accomplishment on account of employment of inadequate or ineffectual means. That's impossible crime. The second paragraph of Article 4 provides for impossible crime. Now, under paragraph 1, a person is criminally liable when for his act when he was committing the felony and the injury he caused is a natural, direct, or logical consequences or consequence of his act. Now, paragraph 1 of the of Article 4 of the Revised Penal Code applies to 1. LLM personae, 2. Habeas ictus, and praeter intentione. We'll discuss those three principles. First, LLM personae, mistake of the identity of the victim. The crime is punishable under Article 49, and the lesser of the crime penalty for the lesser crime is imposed. So we'll deal with Article 49 later. Aberratio ictus means miscarriage of law thereby hitting a different or another victim. I think we already discussed this. And praeter intentionem. Praeter intentionem is or means that more serious injury was more serious unintended injury or consequence befell the victim. So I think we already discussed also that any person committing a felony, as a rule, is liable for the direct, logical, natural consequence of his action. So whatever the result of his criminal act, he will incur criminal liability. Article 6, consummated, frustrated, and attempted felonies. This is important. we will I will have illustration for this inserted in this lecture so that you will or you may understand. Consummated is when all the elements necessary for the execution of an accomplishment are present. So if the crime is theft, the elements of theft are taking of personal property. The personal property is or belong to another person, and there was intent to gain. That's all the elements of the theft. So if the actor or the person took something he does not own, and by taking that something, the intent to gain is implied. If he already took that something, or for example, a ball pen, the crime is already committed. That's consummated. The crime is consummated. The crime is already committed. That's consummated. How about frustrated and attempted felonies? There is frustrated when the offender performs all the acts of execution which would produce the felony as a consequence, but which nevertheless do not produce it by reason of causes independent of the will of the perpetrator. So, simple example of that is when the person committing the felony, like homicide or murder as the case may be, he pointed a gun to another person, and that person or he pointed a gun, and then thereafter he shot another person, and he hit the person in the stomach. But the person is still alive. So he wanted to shoot again, but there exists another third party who tried stopping the assailant or the perpetrators. So when he tried to follow up his shot, he was stopped by a stranger or another person. Thereby he failed to commit the crime of homicide or murder, as the case may be, because of the intervention of another person. That's the reason or causes independent of the will of the perpetrator. Now, there is an attempt when the offender commences the commission of a felony directly by the overt acts and does not perform all the acts of the execution, which would produce the felony by reason of some cause or accident other than his own spontaneous desistance. So, there is a preparatory act and there is a overt acts, the acts of execution. Now, if say for example a perpetrator planned to murder another person by way of poison, he bought a rat's poison, he put it in the food that's supposed to be taken by his intended victim. He already performed all the acts, the overt acts. But some point in time the crime is committed, and after the preparation, he comments by accident he mistakenly gave the food that was not poison. So there we go. He was already convinced to commit the crime. He already performed overt acts in poisoning his intended victim, but by accident he gave to the victim the food that was not poison. So that's attempted stage. Another example of attempted stage is that crime, or you can give me an example of attempted stage if you like. So just imagine in consummated stage, the the elements of the crime were already performed by the actor, and there's nothing more to be done, and the crime is already committed. In frustrated, the the intended result of his action, like homicide or murder, was not produced because of causes independent of the will of the perpetrators. So the perfect example of this is homicide or murder, and the victim was timely given medical attention and was saved. So he performed all the acts of execution, but the felony intended, which is homicide or murder, as the case maybe, was not produced because of timely intervention by medical professional. In attempted stage, he does not perform all the acts of execution. By some causes or accident other than his own spontaneous desistance. So, if the actor or the perpetrator spontaneously desist from committing the act or the crime, there would be no crime, or the person could not be charged with any offense. We'll continue on other articles.